this legal vision, I would like to take IBC. It is nearing 10 years from the inception. It was started in 2016. That is the Insolvency and Bankruptcy Code. It is the biggest one as far as the business world is concerned. The business world expected to solve their more financial problems and credit problem and also debt problems and more things. Due to the financial crisis, many companies got closed and getting closed. They are facing more problems. The litigations are bending. The creditors face more financial problem due to the bending litigation and more things. The debtor, they also face a more problem to solve their financial problems in their own companies or organization. In 2016, the Insolvency and Bankruptcy Code was introduced. After the introduction of this code, many acts regarding the banking or really SIC Industries Act, SIC Industries that is also Act, and also the Financial Crisis Act and the Financial Recovery Act and more things and more acts have got summed up into the Insolvency and really and the Bankruptcy Code. The Debt Recovery Tribunal, which is facing more cases, and also the High Court facing more case, having the more cases or litigation regarding the company liquidation and more things. But now in the IBC, it gives a much powers to the authority, as committee of the creditors and more things. More cases are pending in the High Courts and Supreme Court of India connected with the IBC. Despite IBC it also is having a much provision to recover it is also in the finance from the losing companies and losses and everything. The bindings are more. The claims after introduction of the IBC, nearly in the 10%, 25% only have been recovered. The remaining matters also are pending in the courts in the form of the litigation. Whatever may be, the IBC is very speed. It is a very speed than other acts. The other acts are very slow, its provisions are very slow. That's why there's also the process of the litigation had been slow. But now it's in the procedure only it's also making it slow, not the act provision. The provisions are very strong and it gives a much teeth to the authority to solve the problem. The Supreme Court of India is solving many cases as early as possible in many financial companies and many companies, and under the liquidation, that's also they face that there's also more problems, so the more problems have been solved under the Insolvency and really Bankruptcy Code. The code also gives a much effect. You can take more example from the Supreme Court of India orders in many cases. It has given the guidelines also. It is the most example. This also for speeding up the litigation under the IBC after the inception of the IBC. The IBC it is also which gives a much powers to the authority to solve it. The litigations are filed up due to the procedural lapses or procedural delays, not due to the IBC. So the IBC is very strong. It gives also powers to the committee of the creditors and more things. And whereby when we come into the IBC, automatically the problems are solved easily. If you take it as also total sum up of the others also litigation pending in the courts, only 25% are recovered. Despite it, the speed is at large. The speed is also on the track. So the IBC is the best one. After the inception in 2016, it has got speeded up, and within completion of the 8 years, the trials and other things are very best, and it's moving forward. But it will move forward in future also. The IBC is a very strong one. So the central government has found a new legislation to move forward as far as the business world is concerned. The business world is the biggest world, is pumping the finance and everything. Here, the stocking and the source on the lacking should be removed. That the IBC is doing. So Insolvency and Bankruptcy Code, after its inception, is giving us also much solution to the business liking in India. It will do in future also. Thank you.